Good morning and good afternoon to all of you who've joined us here today. We welcome you to McGuireWoods 2024 California Employment Law Update. My name is Sabrina Beldner, and I am a California Labor and Employment Partner and the chair of our Labor and Employment Group, and I'm joined here today by my colleagues Andrew Russell and David Schwartzstein. Today's webinar is designed to be for information purposes only, and the information we're sharing with you today is not designed to serve as legal advice in a particular situation. If you do have concerns or questions about this information and how to implement changes or a particular fact scenario, we would urge you to contact one of the speakers or your legal counsel after this presentation. Now, during this presentation, you may submit questions in the chat. We are going to hold questions until the end, and depending on time and the substance of the questions, we may send out answers as opposed to trying to answer and field questions live. Just wanted to let everyone know that. Thank you again for joining us today. And with that, I'm going to turn it over to David to kick us off.
Hi, good morning or good afternoon, depending on where you are. Starting with the new laws for 2024, one of the prominent areas that's going to be impacted is the area of restrictive covenants. Now, restrictive covenants include non-compete agreements where an employer and an employee sign an agreement that effectively says the employee cannot compete with the employer after they leave the job, or it can't recruit their customers. And there's also other restrictive covenants that may also be impacted by the new laws that include customer and employee non-solicitation agreements, where the employee agrees not to divert the employees or the customer relationships of their former employer, usually to deal with them, where they are now working. And we have two new laws that are going to be relevant in this space. The first one is AB 1076, and the second one is SB 699. Both of them expand California's ban on non-compete agreements in different ways. California has had a ban on non-compete agreements for over 100 years. It's a little bit different than many other states where you have what's called the rule of reasonableness, that effectively allows certain limited restrictions, temporal restrictions, and geographic restrictions for such agreements. But California has long banned these types of agreements. The first law that we're going to be looking at today, AB 1076, has three key elements that you're going to want to know about. The first is the addition of this section 16600.1 that makes employment non-compete agreements unlawful, not just void. Employers cannot now require an employee to sign a non-compete agreement or to include a non-compete provision in an agreement. Oftentimes you might see such a provision in an inventions agreement, but it can also be in other types of documents. Again, there are some pre-existing statutory exceptions that apply. Usually they relate to the sale or the solution of a business. But more generally speaking, the typical situation where you've got an employee who's leaving the company and signing with these agreements, California is now made those types of agreements unlawful and not just void. The statute also says that a violation of this section is now an act of unfair competition. And that is under the California's unfair competition law, which already has been a source of litigation for employers in the state. Now, what about employers who have already had these types of agreements signed with their employees? The law also addresses that. The new law addresses that and now requires employers to provide notice to current employees and to former employees who've been employed in the last couple of years on or after January 1st, 2022. And it requires the employer to provide notice to them, written notice, individualized written notice that lets them know the agreement that you signed with us or the clause that was a non-compete clause that you signed with us is void. The notice is to provide it to them in writing. It has to be sent to them to their last known address or their current address, and by email as well. So there's a pretty significant immediate action needed for employers that have had these types of agreements in place, even if they're no longer distributing them, but they distributed them in the last couple of years. There's a pretty short deadline to take care of this. The requirement to send out the notices by February 14th, 2024. So this is a very special Valentine's Day present for employers. We expect that plaintiffs' attorneys are going to be jumping on this opportunity for litigation with the law now making this an unfair competition act under the unfair competition law that has already been, a source of litigation for employers. So we do recommend that employers are going to want to retain copies of the letters and any delivery receipts as appropriate, so that they can document that they actually sent these letters and complied with the notice requirement. The third feature of the law is that it amends the existing Section 16600, which is the provision that's been in place now for a long time, and just generally says non-compete agreements are banned. Agreements that restrain a person's ability to engage in their job or to be in trade, all those types of agreements are banned. And the law says we're going to make sure that everybody knows this is a broad application of this standard. And it is in accordance with the 2008 landmark decision from the California Supreme Court in the Edwards v. Arthur Anderson case, where the court reiterated that Section 16600 applies to employment non-compete agreements and doesn't permit any sort of limitation, no matter how reasonable or how minor it is, on their ability to seek employment afterwards. The amendment now goes on to state that the prohibitions against non-compete restrictions are not limited to contracts where the employer or the person being restrained is a party to the contract. What this means, what the scope of this is not clear, but read in the context of the Edwards decision that has a pretty broad application and pretty broad language, this new provision or this new language that we just discussed could be read to ban other types of agreements like employee non-solicitation agreements or other agreements that have the impact, even if not intended, to restrain someone from being able to engage in their employment or trade. One example, for example, would be just business-to-business contracts that prohibit hiring each other's employees. That is an example of one of the agreements that could be impacted by this new language. As if that wasn't enough, California legislature piled on with SB 699, which adds Section 16600.5. That makes it unlawful for employers to not only enter, but to attempt to enforce a non-compete agreement or other type of restricted covenant that is banned, void under California law. And it also provides a private right of action. So this is a second avenue for employees to litigate against companies with respect to these agreements. This provides the ability for employees to obtain damages, to get injunctive relief, an order from the court, and to get attorney's fees and costs with that kind of litigation. The law, the SB 699, also has an additional wrinkle or an additional dimension that says that the employment non-compete agreements are void regardless of where the employee worked and regardless of where the agreement was signed. What is the intended scope of that? That is the obvious question. The statute seems to indicate in the findings, the legislative findings that are included in the bill, that it's really meant to target the impact of those agreements on California or within California rather than outside of the state. The language of the statute is pretty broad and doesn't directly make that limitation clear. So we do expect to see that there's going to be some litigation and development in this space for that reason. All of these changes leave a number of questions open. Notably, as we said, what kind of agreements are covered? Obviously, non-compete agreements of the traditional type, but what other kind of restricted covenants are going to be reached by the new laws? We also don't know yet how this is going to impact Labor Code Section 925, which allows employers to choose a different law or venue provision for their agreements and has been used to try to avoid certain restrictions on agreements. How will that run up against the new non-compete laws and new non-compete statutes? That's not clear yet. We also are going to see questions as to how other states are going to react to this. What are their courts going to do? Will other states enact their own set of litigation to sort of combat California or to follow California's lead? And then ultimately, of course, there's any number of unintended consequences including, for example, efforts by non-California employees to exploit the new law. We do think that because of these issues and because of the new private right of action and the ability to pursue litigation under existing statutes, that we're going to see, some development here in the next few years and probably a good deal of litigation. There is, of course, immediate action that is required by the statute for employers that have used this agreement, but we're also going to want to have some proactivity for all employers, even if they stopped using them, and to really sort of evaluate the risk that they have with these agreements or other agreements that have provisions that could be challenged by plaintiffs' attorneys as being covered by the new law.
Thank you, David. I'm going to jump in and talk about some changes to cannabis use and employer testing in the workplace. As many of you probably know, California has long held that it is legal to use marijuana both from a medicinal perspective and a recreational perspective. But while that has been the law, California has also traditionally said that employers do not have to tolerate marijuana use in the workplace. This new government code section 12954, which takes effect on January 1st, impacts and brings some changes to the table. First, it prohibits discrimination against employees for off-site cannabis use. And second, what's more important is the testing change. The new law prohibits employers from using drug tests which detect what is described as non-psychoactive cannabis metabolites. For those of you who aren't cannabis educated, what that actually is that's pretty much the way all of our current cannabis tests work. Traditional hair and urine tests use this method of testing. And when you test for non-psychoactive cannabis metabolites, you're essentially testing for how any consumed THC breaks down in the system. The problem with this testing and the reason California is making this testing prohibited is it really only proves that there's cannabis in the system. It does not show that it was consumed within, say, the last 24 hours. It can show marijuana that's been consumed within the last 4 to 6 weeks. So you could truly have an employee who went on vacation to Jamaica, partook in, some cannabis consumption there, came back 3 weeks later, and still tests positive. So the California law is prohibiting this type of testing now. The problem with this is, while California says, hey, employers, you can still use tests for applicants and employees, but they have to actually screen for psychoactive THC. Okay, well, the problem with that is the testing that screens for psychoactive THC is not far enough along. It's still majorly in the research and development phase. There are only a couple of companies that have rolled something out. And of course, it's completely untested legally. So these types of new tests for psychoactive THC have not gone through the systems and are still subject to questioning. The other thing we want to mention for each of you is we know many of you may have drug testing vendors that you work with, and you should not assume that your drug testing vendors are immediately transitioning to a test that's going to be lawful under California law. They may not have access to one either, so we would encourage you all to connect with your drug testing vendors to see if they have something in place or a plan to combat this change. So if you're sitting there and saying to me, Sabrina, is there anything we can do here? We have lots of people that we do not want to potentially be impaired. Just to start, there are certain exemptions from this new law, okay? And those exemptions include anyone in the building and constructions trade, positions that require a federal background investigation or security clearance. And this third exemption is a little broader, and it's kind of two-pronged. The first is positions which require drug testing pursuant to other state or federal laws. Okay, so some of you can breathe a sigh of relief. Commercial drivers, still subject to drug testing under federal DOT laws. And what this means when folks are exempted from these laws is they can be tested under the current methodologies allowed under the federal standards, not this new state law. The other thing is, many of you who are government contractors probably don't like being government contractors. Today's a day to cheer about it, because if you're a government contractor where drug testing is a condition of employment or a condition to receive federal funds or federal licensing benefits or a condition of entering into the federal contract you're also exempt from this new cannabis testing requirement. Now, some of you are sitting there and saying, I don't fit into these exemptions, but I have forklift drivers, I have machine operators, I'm still concerned about their impairment. What are we supposed to do? Unfortunately, the law right now as drafted does not contain a safety sensitive exemption for all these different jobs. So you're going to want to look very carefully at surrounding laws. You're going to want to partner with your lawyers and your environmental health and safety experts on whether there are other laws that could mandate in these particular jobs that people still be subject to testing. You're also going to want to talk about tightening up your policies. Do you want to have, for instance, stricter search policies? And the one thing to keep in mind is this doesn't mean you have to tolerate cannabis use in the workplace. Okay, you still, as an employer, have the right to prohibit possession, sale, or use in the workplace. So if you wind up, finding, somebody gets into an accident at the workplace and you search their car and find marijuana in it, you can terminate them if your policy prohibits having cannabis on company property, for instance. So you still want to think about the other avenues that you want to have available to you. In light of this law changing, I will point out that there are a lot of companies that are aggressively trying to come up with the right kind of testing. So California employers can use psychoactive testing. So I'd encourage you to keep your eyes out. This is going to be fast changing as they try to bring something to market. Just like with the non-competes, California wasn't content to stop with one legal change. They added a second one relating to cannabis. And this one relates to asking employees about prior use of cannabis or their criminal history involving cannabis use. You're now prohibited from doing that. There's obviously an exception, and that's if the employer is allowed to consider or inquire about that information under another state or federal law. And that expressly includes California Government Code Section 12952, which allows criminal conviction inquiry for a number of limited positions, such as positions where the state or local agency requires background checks, criminal justice agency positions, or any type of position where a federal or state agency requires criminal background checks. And again, these are cannabis use considerations. This doesn't mean that if somebody was, arrested with 85 grams of marijuana and charged with possession with intent to sell, that's not something you can consider. But really, California is trying to take off-duty use out of the equation for employees unless it is a very limited exception. So just proceed with caution in terms of marijuana use conviction as it relates to employees, unless you've determined that they fit within one of the narrow exemptions. And with that, I'm going to turn it over to Andrew to give you more good news.
Perfect. So SB 616 goes into effect in January 1st. To make some changes to California's paid sick leave laws. So the biggest thing that is going to impact employers is now it increases the annual amount of sick leave that employers need to provide their employees. So it goes up from 3 days or 24 hours to 5 days and to 40 hours. And when we talk about this, we're obviously talking about the state requirements. And we always remind our clients and employers that there are a lot of different local ordinances around California that may, in fact, actually require employers to provide more sick leave. Los Angeles is a good example where the requirement is 48 hours. And to the extent that there's ever a conflict between state or local law, we always want to make sure that we go with the more protective and larger amount to be provided to employees. The new laws do make clear, though, that employees who are working under a qualifying CBA who would be exempt from the accrual requirements, they may continue to be exempt, but this new law makes clear that those exempt employees under a CBA need to be able to use the paid sick leave that they're entitled to for the same reasons as any non-CBA employee. So the full list of requirements are listed under the section there, but it means that the employees need to be able to use their paid sick leave for preventative care, for treatment, both of themselves or family members, They need to be able to use the paid sick leave if they are a victim of domestic violence or circumstances where they may be dealing with stalking. And it also provides the protection now that these employees can't be retaliated or discriminated against for taking paid sick leave. And they can't be forced to find a replacement for somebody when they're taking time off in connection with the use of paid sick leave. The changes to the paid sick leave law make it clear that employers can continue to use either the front-loading or accrual methods. I tend to recommend the front-loading method as a way to make it a lot more administratively easy. You don't need to worry about some of the problem with accruals going astray or running into cap issues. But the law makes clear you can continue to use the accrual method. And if you do have a cap on the amount of sick time that employees can accrue, the new law here increases the limit of that cap from 6 days to 10 days. Again, we want to also be mindful that there are a lot of municipalities that have local ordinances that may differ. Again, we want to always make sure that we're providing the most protection for employees so we don't run astray. So Los Angeles, for example, has a cap that is lower than 80 hours. So in this instance, the 10-day, 80-hour cap would apply. For those employers who are using an accrual method other than the typical 1 hour sick leave for every 30 hours work, the new law makes clear that's okay. We just need to make sure that employees will accrue at least 40 hours of paid sick leave by the 200th day of employment each calendar year or each 12-month period.
Thank you, Andrew. So jumping back in, as you all know, California has a number of different types of protected leave where employees can take time away from work, and SB 848 enacts another leave for what is known as reproductive leave loss. It adds a new government code section 12945.6, which provides an employee with up to 5 days leave for each reproductive loss event. And just so you know what those events are, this could be a failed adoption or surrogacy, a miscarriage or stillbirth, whether that miscarriage or stillbirth is experienced by the employee or the employee's spouse or partner, or unsuccessful assisted reproduction, which you should think of as like IVF or an embryo transfer. And again, whether that is the employee or the partner of the employee, it does not matter. This leave must be provided to employees who've worked for an employer for at least 30 days. And the employee's right to take the reproductive leave it needs to be taken within 3 months of the actual loss event. It doesn't all need to be taken at once. So like FMLA and CFRA leave, it can be taken in chunks. An employee can take 2 days 1 week and 3 days 2 weeks later. Another thing to note is that the leave it's unpaid, but under the law, an employer has to allow an employee to use available paid time off, whether it's vacation or sick leave. This would qualify under the sick leave statutes reasons for using the time off anyways. So most employees will have some availability to take paid leave should this occur. And you may be wondering, well, what about somebody who may be prone to miscarriages, have more than one in a year, or who may go through several unsuccessful rounds of IVF within a year? The law contemplates that, and it specifically provides that for multiple reproductive loss events, an employee's available leave in a 12-month period is capped at 20 days. So essentially, one employee can get up to 4 full reproductive loss leaves in a 12-month period. So, this situation could play itself out, as I mentioned, kind of in where unsuccessful IVF is happening. So you need to keep that in mind. There's a non-retaliation provision in the law. So obviously no retaliation against anyone for taking this type of leave. There's also an interesting confidentiality provision in this new law, which states that you need to maintain the confidentiality of the requesting employee related to the reproductive loss leave and only disclose information to internal personnel or counsel as necessary or required by law. And that's a little unique because while many laws and California generally expects employee confidentiality, very few are as specific as this. And this type of thing is something that, supervisors may casually mention, right? If, for instance, you knew an employee was pregnant, she suffers a miscarriage and is then out of work, and someone says, well, where's Jane? Supervisor says, oh, she lost the baby, right? So you want to be mindful of this confidentiality obligation and coach your leaders going forward, because it does appear to be more stringent and very much specifically included in the statute for a purposeful reason, which we don't often see. And with that, I am turning it back over to Andrew.
Perfect. So SB 553 arises out of kind of recent events in the news where there have been incidents of workplace violence, and it adds section 6401.9 to the California Labor Code. And this new law requires that all California employers establish a written workplace violence prevention policy. This needs to be a written policy. It can be posted on a bulletin board, on a company intranet. It can also be included and added to the injury and illness prevention program as a section, as a separate section, as part of the program already required, or it can be its own separate written document. But it needs to be made available and accessible to employees. And when employers are thinking about putting this together, need to also thinking about whether different work sites might have different hazards, such that a one-size-fit-all policy may not be the best option. It may need to be adjusted based on different work sites. A lot of the laws we're talking about today go into effect on January 1st. This is one of those where employers are going to have some time. It doesn't go into play until July. And so as a lot of employers tend to do, right, we tend to wait till the last second. This is one of those things we recommend, get started on now. You have a little time, use the upcoming half year to get ready, get it in place. I should mention also that while this applies to most employers, it doesn't apply to certain healthcare facilities, work sites that have fewer than 10 employees, that don't have interaction with the public, and for those employees who are choosing to work remotely in locations not controlled by the employer. When employers are putting together this plan, the law is very clear about 12 specific elements that need to be included. I'm not going to try to list them all right now and encourage everybody to look at the specific provision to get all those requirements. But some of the highlights include making sure that employees or employee representatives have an opportunity to have input into putting the plan together. There need to be specific procedures for how employees can report incidents of violence and make sure that these employees do not face any retaliation. And there also need to be specific consideration to how we identify any potential hazards that might exist in the workplace. So obviously this includes a lot of upfront work that needs to be done. But one of the things that the law contemplates is that this is something that needs to be an ongoing examination of the plan. And so employers must annually review and update the plan. Employers are also required to train employees when the plan first is established and then annually thereafter. And it's important there is a record-keeping provision, so keep records confirming information regarding who took the training, when it happened, and what was covered. One of the other requirements with this workplace violence prevention plan that goes with the plan itself is a requirement to keep a violent incident log about each incident that may occur, what happened afterwards, and any investigation that may have been completed. This is not a new reporting requirement. However, if there is an injury that otherwise would need to be reported on the OSHA 300 form, obviously there may be some carryover, but the log itself, there's very specific information that needs to be included. A lot of it seems pretty obvious, right? You need to have the details about what happened for the incident itself, who committed the violence, the circumstances where it happened, and then there are categories for the type of incident that is listed under the provision, and we need to also include information in the log about the consequences of the incident and the person who prepared the log. And one of the things that, when we put on our perspective of our thoughts onto consequences that might stem from this is, this log we anticipate is going to be discoverable in litigation. And so I think when incidents do come up, it provides an opportunity to make sure that we, clients and employers work with counsel to craft the wording of what goes into the log carefully, because these logs may end up in litigation down the road, and so some thought should be put into what's included in the log.
The next law touches on something that many, if not all of you, have likely dealt with, and that is retaliation claims, and a new law that is imposing a significant change in the statutes that pertain to unlawful retaliation under the Labor Code, and potentially beyond that. The new law amends the existing provisions in the Labor Code that relate to unlawful retaliation. Unlawful retaliation, of course, we're talking about a situation where an employee engaged in a protected conduct, and then at some point thereafter, the employee was subject to some sort of adverse employment action, and the employee is claiming that the reason for the adverse employment action was not a legitimate business reason, right? But they're engaging in that protected conduct, right? The protected conduct that is meant to be covered by the new law is, on its face, the Labor Code provisions, the provisions of the Labor Code that allow employees to do things like file a labor commissioner complaint to recover wages or initiate a prior lawsuit, but it may have a broader implication beyond that. The new requirement, or the new impact, I guess, of this law is that it takes the temporal proximity factor when you're looking at retaliation claims, meaning when we're looking at a situation where the employee has claimed that the retaliation occurred, did the protected activity occur closely enough to the adverse employment action to make an inference around whether two of them are connected causally, right? And the law now says there's a presumption that if the adverse employment action occurs within 90 days of the protected activity, there's a presumption that it was an unlawful retaliation action. That doesn't mean that there's no defense. It just means that the employee has a much lighter burden in proving those types of claims. The covered protected activity also includes whistleblower complaints under Labor Code Section 1102.5, and that is where we do see the potential for it to go outside of the Labor Code, because whistleblower complaints under the Section 1102.5 relate to employee complaints where they believe that they're reporting or blowing the whistle, opposing or refusing to participate in unlawful conduct that is in violation of any state or federal law or regulation. And that is where you might be able to see a plaintiff's attorney make the argument that the statute and its penalties may affect an employee's rights, even if it's not a wage and hour type claim or something else that's strictly within the Labor Code. The provision does provide for a civil penalty of up to $10,000 per employee per violation. So this is something that you'll want to be aware of.
Thank you, David. And now I'm going to talk about a legal change relating to employers. Well, it relates to arbitration agreements generally. So if you're an employer who has an arbitration agreement, you want to listen. If you don't have arbitration agreements, now's a great time for you to get up, stretch your legs, grab a cup of coffee. But this year, the California legislature has gifted us with SB 365. And this is an amendment to CCP, California Code of Civil Procedure, Section 1294 of the California Arbitration Act. Prior to this amendment, under the California Arbitration Act, if you brought a motion to compel arbitration and it was denied, that was an immediately appealable order. And under the California Arbitration Act, if you appealed, the underlying proceedings would be stayed pending completion of the appeal. So you'd essentially press pause on the underlying litigation while you waited to see if the California Court of Appeal reversed that adverse decision on the motion to compel. What SB 365 does is it changes this, and it now says that state court proceedings are no longer automatically stayed by virtue of an entity appealing a denial of a motion to compel arbitration. So practically speaking, that has a pretty significant effect on an employer. So, and I'll just walk you through an example. Mike sues you. He has an arbitration agreement. We bring a motion to compel and we lose, and we file our appeal, and it's no longer stayed. Well, while we're waiting for this ruling, Mike can still proceed with his claims in state court as if there is no arbitration agreement, and you're then stuck litigating in two forums. You're spending and investing money on an appeal while you're also litigating in the forum that you claim you shouldn't be litigating in the first instance. So from our perspective, and from the perspective of employers who've been eyeing this law, it's really taken the wind out of an employer's appellate rights, because you can't automatically preserve your interests in potentially going to arbitration. Okay. One thing I will point out is the law has changed just to say that this is no longer an automatic stay. That does not mean an employer can't ask the trial court to stay proceedings pending appeal, and the trial court can still say yes. An employer can also ask their opposing party, hey, I'm going to appeal. Do you want to stay proceedings so we don't wind up doing a bunch of stuff that's wasteful? And if, later on we go to arbitration, none of it's admissible. And if the parties stipulate and agree, the court can also approve that. But you're in a position where you could be on a dual track process. We do expect legal challenges to this law, though. And I will say California has long been hostile to arbitration. Essentially, every major U.S. Supreme Court decision that has come out on arbitration that's been good for employers in the last 10 years has been a reversal of the Ninth Circuit. And so this is just one more of California's efforts to limit the reach of arbitration. But we expect challenges will be made under the Federal Arbitration Act, under the notion that this law is preempted by the Federal Arbitration Act where and when it applies, and that this law in and of itself is just hostile to arbitration. And an important thing to note, just so you understand why we think that could potentially be a successful challenge, is in June of this year, the U.S. Supreme Court decided a case called Coinbase v. Bilski. And while it was a 5-4 decision, as many of their decisions are these days, that case held that under the Federal Arbitration Act, a federal court must stay proceedings when a party appeals the denial of a motion to compel arbitration. So they held the exact opposite of what the California legislature is trying to put in place here. So what does that ultimately mean for those of us who are focused on arbitration as a tool? It means that you should incorporate the Federal Arbitration Act into your arbitration agreements expressly. There are provisions in California law which still say if you incorporate the Federal Arbitration Act, that's what applies. And that will at least give you the argument to say that this SB 365 is preempted under the Federal Arbitration Act, or the FAA as we call it for short. Another thing we think that is going to be critically important still is being strategic about removal to federal court. Some employers have decided, I'm not going to remove to federal court because I have the arbitration